This typically happens if you are delinquent on your payments on a house, car, or other secured loan. The court will generally conclude that if you are not paying for it, then you don't deserve to keep it. Now, this does not apply to property obtained with an unsecured credit card debt. For example, if you buy a toaster with a Visa card, Visa's probably not going to come after you and ask for the toaster back. Unless, of course, you bought the toaster immediately before filing, in which case they may ask for the money back for the charge. But you'll probably get to keep the toaster.
About 30 days after filing, you attend what is known as the 341 meeting, commonly referred to as the meeting of creditors.
This is a meeting of your creditors, and its name refers to Section 341 of the U.S. Bankruptcy Code. It requires your attendance.
Here's an important point. The trustee gets a percentage of whatever he takes from you and sells, so he is motivated to find things that you may try to hide.
Do not hide anything, or the trustee may be the one that recommends that you get criminally charged. Now, there's going to be other people at this meeting as well. They're probably not your creditors. More than likely, they are other debtors and their lawyers. Although a creditor may show up for your case, it's not very likely. This is probably because there is little the creditors can do to hurt you in bankruptcy if you have honestly filed your schedules and you have very little in the way of assets. The meeting itself takes about 5 or 10 minutes once your name is called. The trustee will ask you to provide identification in the form of a driver's license or a state picture identification card, as well as a second form such as a Social Security identification, a W-2, a paycheck stub, or some other form of secondary ID. The trustee will then swear you in under oath. This oath states that you will tell the truth. The hearing is conducted under penalty of perjury, just as if you were in a courtroom in front of a judge. The trustee will ask you a series of questions that may vary from trustee to trustee and even from debtor to debtor in front of the same trustee. And the debtor will typically receive a notice of discharge in about 60 days. This notice does not come from your attorney's office. It is an order from the United States Bankruptcy Court indicating your debts have been discharged, meaning the creditors can no longer pursue you for these debts. The debts that were eliminated in the bankruptcy are not individually listed on the discharge order. So don't think that there's something wrong with your bankruptcy if you don't see them on this discharge order. Your debts have been wiped out.
Certain debts are not dischargeable in bankruptcy. These include marital support like alimony and child support, student loans, intentional harm to others like punching someone. You can't get rid of their medical bills, municipal fines like traffic tickets, certain taxes that we discussed earlier, DWI fines, or harm caused to someone else while driving while intoxicated. There are 4 primary types. First, actual fraud. Let's say you fill out a loan application and lie, and say your income is $60,000 when you really only made $30,000.
The creditor could say your debt was incurred through fraud, meaning they relied on your false statement in making their decision to lend you money. And they may claim you cannot discharge this amount in bankruptcy.
Second, debts for luxury goods which cost more than $500 and were purchased within 90 days of filing.
Basically, if you think you're slick and you decide to buy a big screen television and then go bankrupt, this plan will not work, and this action will be presumed to be fraudulent if it was done within 90 days. Now, this doesn't mean wait 91 days. The creditor can still show actual fraud by proving the debtor did not intend to make the purchase or did not have the means to make the purchase. It's then up to the judge to decide this on a case-by-case basis.
Third, cash advances in excess of $750 within 70 days.
They are presumed fraudulent, meaning you, the debtor, has the burden of proving that taking the money so close to filing the bankruptcy was not an intentional fraud.
Finally, debts for crimes like embezzlement are considered fraud.
This is where you are trusted with someone else's money and you decide to use it for your own purposes. For example, you collect and you're in charge and control of money for a charity, and then you decide to use the money to buy a new car for yourself. Theft is also considered fraud. Debts from any of these actions are considered fraud and may not be discharged in your bankruptcy filing.
Be aware, your creditors may object to the discharge of your case if you engage in certain inappropriate conduct or fail to comply with the bankruptcy process requirements. This means they ask the court to enter an order which basically nullifies your bankruptcy filing and allows your creditors to pursue you again.
Typical examples include making false statements in your bankruptcy schedules, concealing property or assets of any kind, falsification of documents, destruction of documents, or refusal to produce documents. It may also include an inexplicable loss of money or an asset, meaning that the trustee knows you had it at one point in time, but now you just can't explain what happened to it. For example, you sell a house in February and you make $50,000 off the sale. You then file your bankruptcy 5 months later and it can't explain what happened to the money, or you have some lame explanation. The most typical one used is,
I gambled it. Yeah, gambled.
believe me, the judges and trustees have heard this one before. Unless it is actually true and you can somehow prove it, they'll probably just stare at you like you're just a big fat liar, and then they may revoke your discharge anyway.
I'll give my brother my $15,000 motorcycle for $50 2 months before I file.
Repayments to friends or family members are considered insider transfers and are a big no-no. Therefore, you cannot take your $20,000 in cash in your bank account and then say,
Oh, I had to give that to my brother John because I happen to owe him $20,000.
any repayments to friends or family members within 1 year are considered fraudulent. They will go after your friend or family member to get the money back. Finally, another likely scenario is if you didn't wait the 8 years since you filed your last Chapter 7 bankruptcy, then the creditor may object to your discharge.
Another thing to bear in mind is that the trustee may also move to dismiss your bankruptcy, which basically has the same effect of rendering your bankruptcy filing useless.
The most common reason is failure to show up for your meeting of creditors. They may continue it one time if you miss your hearing, but after that they will dismiss your case. Make sure you do not miss the meeting. It really makes the trustees angry sometimes. You may have to pay your attorney to attend the extra hearing anyway. Another common reason for dismissal is refusal to turn over an asset that is not protected by an exemption. For example, the trustee finds out you have a jet ski that is not protected and you simply refuse to hand it over. The trustee will file a motion to dismiss your case. Finally, any non-compliance with the request of the trustee, such as for you to produce documentation, etc., that may also result in the dismissal of your case. If the trustee or your attorney asks you for documentation, don't put it on your to-do list. Just get it to them immediately. Well, folks, you've just been given some pretty intense information on the bankruptcy procedure. It is a lot of information, and you may want to listen to the material again. Please keep in mind, this is not legal advice. It is information which is accurate to the best of my knowledge as of the time it was produced. The information and even the laws may have changed by the time you are ready to file your own bankruptcy. Please consult a knowledgeable bankruptcy attorney in your area, and good luck.